In the list item 3 permitted to withdraw.
Memo filed for withdrawal. Yes,
May I please bail application.
give it.
Okay.
Call it.
Supplemental list item number 1.
May I please go? The appellant has been convicted under section 376 only and sentenced to undergo RI for 7 years. He was all along on bail, my lord. I'm serving the deposition copy today, my lord. All right, admit call for the trial court report. Deposition copy served on the London Council for the state in court. My lord. Interim application for bail and stay realization of fine to be considered after receipt of the trial court. Yes. Lordship. Okay.
Item 2.
Yes, Ms. Nando.
May I plead Lordship? 13(1)(d) and 13(2) of this act, my lord. Convicted for 3 years.
Maximum sentence is 3 years.
3 years. During trial, he is all along on bail, my lord. Running pace 62 and 60 cooperated part of the judgment, my lord.
Proceeding Mahapatra. Okay, as it appears, some other persons were also faced trial and they have been found guilty.
My lord.
So, Mr. Das, any other criminal appeal pending before this court?
CRLA 157-162 of 2024 have
Just
been
a minute.
admitted by your lordship.
CRLA number, please, once again.
157-162.
Yes. Yes.
Both have been admitted by your lordship on
No,
157
of which year?
this 2024
2024. Okay.
5-3 admit LCR have been called for.
All right. A hard admit call for the trial court record. The appellant was on bail, so bail allowed. Stay realization of fine. Mr. Das undertakes to file the appearance memo by end of May. Free copy of the order be handed over to Mr. Das. Mr. Das submits that there are 2 connected criminal appeals filed by the co-accused persons, which are registered as CRLA number 157 of 2024 and CRLA number 162 of 2024. Henceforth, this criminal appeal shall be listed along with such and such. It is stated that trial court record has already been called for in those 2 criminal appeals. The registry, before calling for the trial court record, shall verify about regarding the availability of the trial court record in those 2 criminal appeals. Yes.
Free copy of the order, my lord.
Free copy. Yes.
Obliged.
Item 4.
May I please, my lord?
Yes, Mr. Mahanti.
May I please, my lord?
Yeah.
I am at VC Sambalpur. I have preferred this is
just a minute. Just a minute. Notice sufficient?
Yes, my lord.
Since when?
Date not mentioned.
When you did receive the intimation from the IAC?
Dasa 3-23.
In 3 means 1 week time has not elapsed.
Yeah, 23-23. Dasa 3-23.
23 कौन कौन Authority of the phone.
23
ନାଇଁ ନାଇଁ ଆପଣଙ୍କର ଏ କେସ୍ ଟା ଫାଇଲ ହେଲା 9/11/2023 ରେ ତ 10/3/2023 ରେ କେମିତି ନୋଟିସ
sorry my lord that CD file এটা আছে 12/2/24
ସିଓର ତ
yes 12/2/24
okay yes Mr. Mahanti, you can argue the matter. So it is a criminal appeal for bail under SC/ST Act. What is the date of custody?
Date of custody 22/4/2023
22
22/4/2023 April.
Okay. What are the offenses under which charge sheet submitted?
Registered under section 302 IPC.
There is some problem. I'm not able to hear all the. Please, no. It is system assistant. What you are doing? Yes. No. I'm not able to hear you. With the system assistant, come to the front. What is the problem?
Sir, I have checked, sir.
No. But the learning council's voice is not coming.
Audible now, my lord?
It's audible. Yes. Please. Okay. What are the offenses under which charge sheet submitted?
Initially, the case was registered under section 302 IPC. Subsequently, it was turned to 147, 148, 323.
So I just want to know what are the offenses under which charge sheet submitted. Have you got a copy of the charge sheet with you?
Yes, 302 more
Yes.
particularly, and 31R, 32V, VA.
Just a minute. Go slowly, mister. Go slowly. 31R.
31R, 32V,
Yes.
VA
Yes.
of SC/ST POA Act.
Right.
147 148
Just a minute. 147, 148,
323
323,
326
326.
302
Yes.
307
307.
153A.
These are all charge sheet offenses.
Yes, sir.
Yes.
Then why did you say only 302? Yes.
506
Yes.
149 of 3 SC/ST Act.
Okay. So what is the name of the deceased?
Chandramani Mirza.
What is the date of occurrence?
4/2023. 14 April 2023.
Is there any must be eyewitness because 326 etc. are there.
Several eyewitnesses.
So they tell name one of them.
One is Sheikh Imran.
Sheikh Imran.
Yes.
Okay, please read it out.
Yes, ma'am. ମୋର ନାମ ଶେଖ୍ ଇମରାନ। ଆଜି ହାଜର ମୁଖ୍ୟ 14/4/23 ତାରିଖ ଉପର ବେଳା ସନ୍ଧ୍ୟା 7ଟା
Adjust the mic, Mr. Tripathi.
ସନ୍ଧ୍ୟା 7ଟାରୁ 7:30 ଭିତରେ ମୁଁ ଦଳେଇପଡା ବାଟମଙ୍ଗଳା ଗଳି ପାଖରେ ନୂର ରାଜା ସହିତ ଛିଡା ହୋଇଥିଲୁ। ଏହି ସମୟରେ ବାଲିବନ୍ଧ ପଟରୁ ବଜରଙ୍ଗ ଦଳର କିଛି ପିଲା 10-12ଟି ମୋଟର ସାଇକେଲରେ ଜୟ ଶ୍ରୀରାମ କହିକି ଆସୁଥିଲେ। ରିଙ୍ଗ ରୋଡ ଦଳେଇପଡା ବାଟମଙ୍ଗଳା ମନ୍ଦିର ପାଖରେ ସେମାନେ ସ୍ଲାଙ୍ଗ ପଠାଣ ଲୋକ କହି ପଠାଣ ଲୋକମାନଙ୍କୁ ଗାଳି ଦଉଥିଲେ। ମଝିରେ ଗୁଡୁ, ବିଟୁ, ସୋନୁ, ଲକି, ସବୀର ବଟେନ ଓ ଚାକୁ ଧରି ମାରିବାକୁ ଦୌଡାଇଲେ। ସେମାନେ ମୋଟର ସାଇକେଲ ଛାଡି ପଛକୁ ବାଟମଙ୍ଗଳା ଗଳି ଆଡକୁ ରିଙ୍ଗ ରୋଡ ଆଡେ ଦୌଡ଼ିଲେ। ବାଟମଙ୍ଗଳା ଗଳିରେ ଫରାଜ, ପଟୁ, ଅରବାଜ, ରାଜୁ, କାସିମ, ୟୁସୁଫ, ଟେଡି, ହୁସେନ, ହାଇଦର ଓ ଅନ୍ୟ ପିଲାମାନେ ସେମାନଙ୍କୁ ଛୁରୀ ଚାକୁ ଧରି ମାରିବା ପାଇଁ ଦୌଡାଇଲେ।
ପିଟିସନର ନାଁ ଥିଲେ କହିବେ।
ଏହି ସମୟରେ ବଜରଙ୍ଗ ଦଳର ଏକ ପିଲା ତଳେ ପଡିଗଲା। ତାପରେ ପଟୁ ସେହି ପିଲାକୁ ଚାକୁ ମାରିଲା।
କିଏ?
ପଟୁ
PATU।
ତାପରେ ଟେଡି ଚାକୁ ଓ ୟୁସୁଫ ତଲୱାରରେ ମାରିଲେ।
just teddy hela knife tapre
ୟୁସୁଫ ତଲୱାର।
Yusuf sword, yes.
ଏହା ପରେ ସବିର ଏକ ବେଟେନରେ ଲୋକକୁ ମାରିଲା।
Sabir
ୟେସ୍,
putre
ବେଟେନ।
beten, yes.
ଏହା ପରେ ଏମଡି ସୋନୁ, ଗୁଡୁ, ଲୋକି ଅଶଫକ ଖାନ, ଫରାଜ, ଅରବାଜ, ରାଜୁ, କାସିମ, ୟୁସୁଫ, ବିଟୁ, ହୁସେନ କା,
Bitu means this petition
Yes, yes.
appellant, yes.
ୟେସ୍, ହାଇଦର ବେଟେନ ଓ ଚାକୁରେ ସେ ପିଲାକୁ ମାରିଲେ।
Yeah.
ଘଟଣା ଜାଗାରେ ପିଲାଟି ମରିଗଲା।
So that boy is that Chandra Mani Mirdha,
ମିର୍ଜା,
right?
ୟେସ୍।
So what are the injuries sustained as per the PM report?
10 inches wounds Miller.
So what about the criminal antecedent?
4 criminal antecedents.
What are those criminal antecedents?
Yes, sir. That. One is 294,506, 294,323.
Of which year those cases were?
This is of 21.
294,506.
Yes.
Then second one.
Then second one is 294, 323, 341, 379, 506.
Yes. Next.
Third one is 147, 148, 294, 323, 387, 506, 149.
Yes.
And fourth one is 294, 323, 341, 506.
So what is the status of these 4 cases? Mr. Mahanti, are you aware that there are 4?
It is not within my. It is not within my knowledge, my lord.
And
It is not within my knowledge.
what about any accused have been released on bail in this case?
2 persons has been released.
Who are they?
One is an old person, about 70 years old. He was released, and another is Teddy, the juvenile.
Teddy.
Only 2 persons.
And on similar footing with Hussein Khan, who has already been released on bail.
Hussein Khan. One Hussein Khan has been released on bail.
Yes, my lord.
Who has granted bail? By this court or by the?
By this court.
What is the BLAPL number?
BLAPL number, CRLA number 59. CRLA number 598 of 2023.
What is the order dated? Okay, that order is here. Right. I rejected the bail application of Rajia Hussain and Muhammad Yusuf. And so far as Hussein Khan is concerned, taking into account his old age and his conduct in complying with the condition of the interim bail order, so that was the reason why Hussein Khan was granted bail. It's not that maybe that he has been named by the other persons, but he was an old man, and I have also mentioned during the contention that he is aged about 72 years, and he was released on interim bail for 1 month, and after availing the same, he surrendered at right time. So and you are having 4 criminal antecedents, you are not aware. So take instruction and file a comprehensive affidavit about the status of the cases. Lekhandu. Mr.
May I submit, my lord?
Yes.
Initially, the present appellant was cited as one of the eyewitnesses. He was examined as a witness. witness to this case. His statement was recorded on 19/4/2023, 161, 164. His 161 statement was also recorded on 17/4/2023
Hmm.
as a witness to the occurrence.
Hmm.
And till forwarding of the accused, 22/4/2023 পর্যন্ত, none uttered his name. None of the witnesses,
No,
eyewitnesses.
the statement which
It was
Mr.
recorded subsequently, Your Honor.
What is the date of
After,
that statement?
after forwarding of the accused, after
Please.
forwarding of the appellant.
26/4/23
Present appellant forwarded on 22/4/2023.
So date of occurrence is 14/4/23, and this statement which you read out, that is the statement of Sheikh Imran, that was recorded on 26/4/2023, right? So is it a fact that earlier this appellant was examined as a prosecution witness, and his statement has also been recorded under section 164 CRPC,
Yes.
right? Heard Mr. Surendra Mahanti, Land Counsel, appearing through virtual High Court, Sambalpur. Land Counsel for the state submitted that notice on the informant has been made sufficient since 12/2/2024. Stop. None appears for the informant. Mr. Mahanti, Land Counsel for the appellant, submits that the appellant Bismay Kumar Behera alias B2 is in judicial custody since 22/4/2023. And he has been charge sheeted under section 147, 148, 323, 326, 307, 302, 506, 153A, read with section 149 of the Indian Penal Code and section 31Rs /32B and BA of the SC/ST/PO Act. The occurrence in question took place on 14/4/2023. Have you given the FIR copy? Who has lost the FIR?
A Havildar, namely Ranjan Kumar Sahu
Havildar,
of Town Police Station.
one Havildar of Town Police Station, namely Ranjan Kumar Sahu.
Ranjan Kumar Sahu.
Mr. Tripathi,
Yes.
informant is Ranjan Kumar Sahu. Is it Ranjan Kumar Sahu?
Yes, my lord, Ranjan Kumar Sahu.
Ranjan Kumar Sahu lost the first information report. On the very day, on that 14/4.
On the very day,
Okay.
on the very same day.
Is it named against some persons or unknown
No,
person?
no, unknown person.
Which was
Against
lost,
unknown person.
which was lost against unknown persons. During course of investigation, the appellant was examined as an eyewitness to the occurrence, and his statement was recorded under section 161 CRPC, so also by the magistrate under section 164 CRPC. And subsequently, he has been arraigned as an accused on the basis of some concocted statements, and no specific overt act has been attributed against the appellant. relating to the commission of murder of the deceased Chandramani Mirdha. Land Council further submits that one of the co-accused, namely Hussein Khan, so that bail order, that CRLN 598, has already been released on bail by this court in CRLN number 598 of 2023, as per order dated 9/10/2023. And therefore, the bail application of the appellant may be favorably considered. Learned counsel for the state, while not disputing that the petitioner was examined by the investigating officer as an eyewitness to the occurrence, and so also his statement was recorded under section 164 CRPC by the magistrate, place the statement of one Sheikh Imran, an eyewitness who has implicated the petitioner and others in the assault of the deceased Chandramani Mirdha.
So also Nur Raja Khan.
Nur Raja Khan. Sheikh Imran and Nur Raja Khan.
164.
The statements, place the statements. Sheikh Imran no kon 164 is?
Yes.
Acha, tale 161 as well as 164 CRPC statements of witnesses Sheikh Imran and so and so. Land Council for the state further submits that the post-mortem report indicates that there are as many as 10 incised wounds sustained by the deceased on different parts of the body. And there are 4 criminal antecedents against the petitioner. The Learned Counsel for the state further submits that the co-accused Hussein Khan, who was granted bail by this court, was a man aged about 72 years. And that was taken into account by this court while granting bail to him. Though, as per the statement of the aforesaid 2 eyewitnesses, Sheikh Imran and Sejwara Nada Koile, the petitioner, the appellant, is similarly situated like Sheikh Yusuf. Considering the submission made by the Learned Counsel for the respective parties, nature of accusation against the petitioner, the young age of the petitioner, period of detention of the petitioner in judicial custody, and since one of the co-accused has already been released on bail, I am inclined to release the petitioner appellant on bail subject to condition that he shall not indulge in any criminal activities. He shall appear before the Learned Trial Court on each date when the case would be posted for trial, shall not try to tamper with the evidence, violation of any terms and condition shall entail cancellation of bail allowed. Yes.
Item 5. Item 12.
May I please? Last time Lordship directed the registry to verify whether the matter is CRLA or BL fail. Charge sheet filed under section.
Please wait, please wait. Last time it was listed on 15/12/2023. Prior to that, okay. Notice has been issued because one of the offense is 3 SCSTR.
Yes, ma'am.
So what happened?
Oh, notice has been served.
What is the date of?
25/10/23. And the rejection is from Special Judge SCST Act Court. That he should file criminal appeal.
No, we have already passed an order to that effect that the stamp reporter shall submit a specific note as to whether a bail application is maintainable or a criminal appeal is maintainable. And the report has been furnished. Where is that report? Part C and D. Okay, on the basis of the query made by this court, the deputy register has mentioned like this, that I re-examined the matter and found that the impugned order is appealable under section 14A of the SCST Act. The same fact was not detected at the time of stamp reporting, for which I may be kindly excused for the inconvenience caused to the court. So you are to file a interim application for change of nomenclature, right? So since it's a the rejection order is passed by the special judge under the SCST Act, and then the appeal provision is there under 14A. So bail application would not be maintainable, it would be a criminal appeal.
Yeah.
Since you have filed BLAPL, file one interim application for conversion of BLAPL to CRL, right? Lekhon, here use the report of the DR, which indicates that a criminal appeal is maintainable against the rejection order. Learned counsel for the petitioner seeks some time to file an interim application for conversion of this BLAPL to CRLA. Put up this matter immediately after the interim application is filed. Okay.
Oblige.
Item 13.
CD.
Yes, Mr.
Yeah.
Jari.
13. Made 3 journals.
Same persons, two BLAPL means
2 cases.
two cases.
Madam. I have
So-
some of the, whatever I have obtained, deposition copies.
You have
So I'm
supplied.
having a copy also.
So let him go through it.
Yes.
Can take up
Yes.
tomorrow or day after
Yes,
tomorrow.
yes. In both the cases, I'm serving.
Both the cases,
Both the
witnesses have been examined.
Yes.
All right.
But authentication he has to obtain whether the last one is there or not. Because that
No, you
order,
are filing the certified copy. So what
well,
is the problem?
order sheet has not been given to me, so I do not know. And he is unable to say whether any more.
No.
I have given the certified.
I couldn't follow. You are filing the certified
But in
copy of
one
the.
case, only 2 witnesses have been examined in 22. But he is unable to say thereafter whether any.
I see. Then that instruction is
Well-
to be obtained. All right. You have filed the. So first give one that
I will tell you.
PLAPL number 10305 of 23. Setar diyon. Take down. You receive the set of deposition copy in
Yes,
each
ma'am.
case and
Yes.
accordingly attach it to the concerned file. Mr. Basudev Pujari, Land Counsel, appearing for the petitioner, files the certified copy of deposition of some witnesses, giving copies thereof to the Land and Counsel for the state with a note, which are taken on record. On perusal of the deposition copies, it appears that PW2 was examined on 15th December 2022. Since the Land and Counsel is not filing the certified copy of the order sheet of the Land and Trial Court and is not in a position to say whether any further witnesses have been examined after PW2 or not, let a report be called for from the Land and Trial Court, that is additional session judge cum special judge Parla Khemundi in GR case number 53 of 2020 relating to the status of the case. If any other witnesses have been examined after PW2, the deposition copies of those witnesses, Xerox copy of those witnesses be sent to this court forthwith. And on receipt of the same, the registry shall supply a set of deposition to the Land and Counsel for the state, so also to the Land and Counsel for the petitioner. All right. Similar order in the other
in the
matter.
last case, no, in the last case, the last PW was examined on 15 to 24.
Oh, then it's all right. Acha, theta dekhi na. Second, it how cheap first.
PW 9 was examined on 15 to 24.
Then it is the latest one.
My lord.
Land Council so and so files the deposition copy which are taken on record. The Land and Council for the is also supplied to the Land Council for the state. You go through it and
Yes.
okay. Next week ରଖି ଦିଅନ୍ତୁ ହେଲା ସେଇଟା ରିପୋର୍ଟ ପାଇଲା ପରେ 27 ତାରିଖ ରଖି ଦିଅନ୍ତୁ ଯୋଉଟା ପ୍ରଥମଟା it will come on 27/3/2024 after the usual order କରିଦେବେ register judicial ଙ୍କ ପାଖରେ place ହବ ସେ call for କରିବେ ହେଲା ବାକି ଯୋଉ second item ଟା deposition copy supplied in court he wants to go through the same matter be listed on 18/3/24 ହେଲା yes
Item 14.
Ma'am, please.
On the last 4 application, my lordship, this honorable court granted him interim bail, and positively he was surrendered before time, my lordship, without misuse the liberty of this honorable court direction, my lordship.
This
And,
is the fourth time you have been granted
yes, my
interim
lordship.
bail.
And 4th time I was surrendered before the learned
So
trial.
what is the sentence imposed by the
10 years and 1 year, 1 lakh fine, my lordship. In default,
last time when you were released on bail?
yes. My lordship,
Huh? Kona?
27 to 2024.
24.
27.
my lordship,
27
No, 27 रे 27 ରେ report ଟେ call for ହେଇଥିଲା।
18
ହଁ,
ତାରିଖରେ ଯାଇଥିଲୁ।
last ଇଏ ହେଇଥିଲା ଯେ 16/10/2023 ରେ 3 ମାସ ଯାଇଥିଲା।
I'm
And-
filing all the
No, it's all right. I have called for a report. Let us
and
see
in
that.
the meantime, I have obtained the custody certificate, my lordship, that through email. And
I am submit that the convict so-and-so has availed the interim bail order as per the order of this order and he has surrendered at right time after completion of. ठीक है जी?
my lordship, in the meantime, I have obtained the custodial certificate, my lordship, through email, my lordship, and 274 days are left to complete his conviction period. Out of 10 years, 274 days are already.
Are the learning counsel for the petitioner, learning counsel for the state. The learning counsel for the appellant petitioner no, submitted that out of 10 years of substantive sentence imposed by the London trial court, only 274 days days are remaining for completion of this sentence. He further submits that 4 times the petitioner has been granted interim bail by this court, and after availing the same, he surrendered at right time. As for the order passed by this court, the London trial court has submitted a report dated 5/3/2024, from which it appears that the petitioner has surrendered at right time after completion of the interim bail period. Considering the submission made by the London counsel for the respective parties, the period of detention of the petitioner in judicial custody, the conduct of the petitioner in complying with the earlier interim bail orders, and for the taking into account the ratio laid down in the case of Muhammad Muslim versus Swanso, I'm inclined to release the petitioner on bail allowed.
Bail allowed?
Yes,
Yes, my lord.
Item 16.
May I please your lordship? I'm hearing
conviction.
Yes, my lord. 10 years conviction, my lord,
Surrender
out
certificate means as a custody certificate
of
that you have obtained, Mr. No, I have not received, my lord.
out of my 10 years already undergone 7 years.
ଆପଣ ପାଖରେ
Photo ଦେଖ।
custody certificate ଅଛି ନାହିଁ?
ସେଟା ମଗା ହେଇଥିଲା।
କଷ୍ଟଡିଟା ପାଇନି ଆସିନି।
Next week.
Right.
All right. Learn and counsel for the state seeks some more time to produce the custody certificate. Put up this matter on 18th March 2024.
God bless. Yes. Onward.
हाँ जेल कथा कही दियंतु कोटेश हाँ yes
Item 19.
19
Item 22.
Two. 22, Ramesh. You are there?
Item 22.
22?
Yes.
Yes. You have
Here-
no power in this case?
No, because
Okay.
subsequent it is
All right. What is this prayer for interim bail on what
interim
ground?
bail, my lord. Previously, the petitioner was granted interim bail on the ground of illness of her mother-in-law because her husband is not there in the home. Only two small kids are there. The doctor advised for certain treatment, and by the time before expiry of the interim bail period, the petitioner filed an application for extension, but which was not been granted. Accordingly, she surrendered and files this application. Where the doctor, your lordship will find the surrender certificate is page 10. This along with the present IA.
No, in this particular interim application,
Yes, sir.
491 of 2024.
Yes, sir.
So what ground you have taken
The
for interim bail?
for to get her mother treated at MKCJ.
Mother or mother-in-law?
Mother-in-law, sorry, mother-in-law. The page 12 with the referral certificate.
So what instruction you have obtained, Mr. Das? Copy देना जी.
ଗଲା ଲାଷ୍ଟ ଡେଟ୍ ରେ ଗୋଟେ ଅର୍ଡର ହେଇଥିଲା ସେଟା ରିଜେକ୍ଟ ହେଇଥିଲା ତାଙ୍କର ଆଇଏଟେ
ସେଇଟା
26/2
397 of 2024
ତାପରେ କପିଟା ମୁଁ
ଦିଅନ୍ତୁ ଆଉ ଗୋଟେ କପି ଦିଅନ୍ତୁ କପି ଦେଇନାହାନ୍ତି କେମିତି ଅର୍ଡର No, when I disposed of the matter on 26 to 2024, when I took up this matter,
yes, sir.
an order has been passed that you are to produce the surrender certificate by the next date.
Yes, that is
you
there.
have produced.
Page 10, along with this IA. I was required to, upon expiry of the interim period, I was
Where is
required
that 491?
491.
IA number 491 of 2024. This is an application for interim bail on the ground of ailment of the mother-in-law of the petition.
Yes, sir.
Land and Council for the Land Council for the
The last my record, I'm handing it.
Land Council for the appellant handed over the copy of the interim application along with the annexures to the Land and Council for the state in court today, who seeks some time to obtain instruction put of this matter in the week commencing from 27th of March 2024. Instruction be obtained in the meantime. Of these things,
Can it be 18th? 18th.
No, it's not possible. He has to obtain that because the doctors are to be examined, those authenticity of those documents are to be verified. Yes,
Item 23.
23, Mr. Mahanti.
The last order
2C NDPS Act, my lord, sentenced to undergo a period of 10 years, my lord. Last occasion, your lordship, submit the posted certificate, my lord. Total days 1634 days, my lord.
Wait.
4 years.
State has also produced on supplement 6 for an adjournment. Okay. So the total sentence is 10 years.
10 years.
So have you completed half of the sentence?
No, my lord.
Then
4 years. Something.
so that is not applicable. So once you complete, then that can be done. I'm keeping it after summer vacation. Put up this matter after summer vacation.
Item 30.
Yes, Mr. Pradhan.
May I please? This here the appellant has been convicted under section 304 part 1 of the IPC.
Have you supplied deposition copies?
No, my lord, deposition
No.
copy not.
Then supply it. How can you?
My lord, today I will supply.
The learned counsel for the appellant submits that he will supply the deposition copy to the learned counsel for the state during course of the day. Put up this matter next week. Yes.
Item 31.
Yes, Mr. Biomakis Tripathi. Defect number 5D. 5D का state copy आपने देना दी?
Copy, sir. my lord.
Copy short. Let me do. Learned counsel for the non-appears for the appellant. Learned counsel for the state submits that he has received the copy of the appeal memo. Accordingly, defect number 5D, as pointed out by the stamp reporter, has been removed. What is this criminal appeal for?
My lord, 31 copy not, sir, my lord.
ଆପଣ ପଚାରୁଛି ଆପଣ କହୁଛନ୍ତି copy not, sir.
No, my lord.
The learned counsel for the state submits that she has not received the copy of the appeal memo. Let the learned counsel for the appellant supply the same to the learned counsel for the state within 2 weeks. Yes, next.
Item 32.
Mr.
My
Utsa.
lord.
Yes. Order number 1 dated one, so may kindly be seen. Defect number 5D. 5D is the state copy you have
Copy
received.
supply, my lord.
No,
Under
problem.
9 SR 9 is being aggrieved that and good ground certificate not furnished. Order was passed. Learned counsel submit that both the defects as pointed out be removed within a week. So did you remove those 2 defects? One is removed, that is state copy has been. The other defects regarding mentioning of that being aggrieved, whether you did it before the registry, stamp reporter. Mr. Ota, are you able to hear me?
My lord, in my petition para page 4 last, being agreed with the findings arrived at by learned trial court mentioned in the said para 2, the appellants preferred this appeal on the following grounds among the staff.
Wait, let me see that.
Page 4, my lord.
Just a minute. Yes, sir, Counsel. Being aggrieved by the order and good ground certificate not furnished. Achha. What you have mentioned in your bail application? Being aggrieved. Okay. He says it means to say that it should have been being aggrieved by the order dated so and so. That you have not mentioned. All right. So we can ignore it. What is this CRLA for?
My lordship, the appellant has been convicted and sentenced to undergo RI 15 years and to pay fine of rupees 10,000 and in default to undergo a further array of 6 months and sentencing
Just a minute. It is a 15-year sentence.
15 years.
Okay. Learned counsel for the state has received the copy of the appeal memo. Accordingly, defect number 5D as per SR has been removed. The defect number 9 stands ignored. Hard admit called for the trial court record. You have filed interim application for bail and stay realization of fine. Okay.
Yes, my lord.
Applications for bail and stay realization of fine to be considered after receipt of the trial court record. In the meantime, you supply the deposition copy of the witnesses to the state council.
My lord.
Okay. Let the deposition copy of the witnesses examined in the trial court be supplied to the land council for the state in the meantime. Hard Mr. A.K. Asit Kumar Ota from Virtual High Court, Moidbhanj at Baripada. All right.
Pardon me, Lord. Pardon me, Lord. Item 31, kindly next week, my Lord.
31, I have given you 2 weeks time.
My Lord, my Lord.
I have also mentioned is non-appears. So I am that portion you omit. I have given you 2 weeks time to remove the defect. You want 1 week, you can do it.
My Lord.
5 day, all right. Oh, 2 week jagar 1 week or then. All right. You produce that receipt before the stamp reporter so that the matter can be listed. All right.
As per my Lord's order, already I have filed, but receipt not filed.
ମୁଁ ଜାଣିନି ସେ କହୁଛନ୍ତି ଭେରିଫାଇ କରି ଦେଖିଲେ ତାଙ୍କ ପାଖରେ ଅପିଲ ମେମୋ ନାହିଁ
ଆଉ ଗୋଟେ କପି ଦେଇଦେବେ
ଆଉ ଗୋଟେ କପି ଦିଅନ୍ତୁ କି ଯଦି ପ୍ରମାଣ କଣ ଅଛି ଆପଣ ପାଖରେ ତାଙ୍କୁ ଦେଖାନ୍ତୁ ସେ ଅଫିସ ରୁ ଭେରିଫାଇ କରିବେ ହେଲା yes next
Item 33.
Item 33, 10 days time may be given to file.
Mr. Land Counsel for the appellant 16 days time to remove the defects as pointed out by the stamp reporter of this matter after the defects are removed. Yes, next.
Item 34.
May I please, Your Lordship? Appearing through VC. Appearing through VC below.
VC, is it from
Civil Court, Koraput. Civil Court premises, Koraput.
Okay, why are you not mentioning your name? This system assistant is there?
No, sir. He's outside, sir. I'm TGN Murthy, sir.
You are not doing it from the VC hall.
Sir, Jaipur VC hall is 20 kilometers away, sir.
Okay.
I was appearing in this court, so I immediately logged in.
What is your good name?
TGN Murthy, sir. T. Gopinath Murthy, sir.
P. Gopinath Murthy. All right. Some defect has been pointed out. One is
on last occasion, sir, I was directed to file an interim application for condonation of the delay. I have already filed it on 4th of March, Miller.
What is that? 4th of March, Acha, that has not been tagged to perhaps.
It is registered as IA 543 of 24.
Yeah, just a minute. IA
543 of 24, Your Lordship.
24. You have received the copy of that interim application. So ascertain from the registry whether such an IA has been filed or not. Okay? And give a copy, Xerox copy, and give it to Mr. Das.
Your Lordship should consider who have filed the appeal.
The appeal is with third parties.
How appeal is maintainable here?
Yes.
Who are these petitioners, appellants?
Just a minute. What is this? What is under challenge?
Yeah, maybe he is permitted to submit. The case initially a vigilance case was initiated against the respondent number 2.
Okay.
For alleged offence under section 7(13)(2), Redwick 13(1)(d) of PC Act.
Okay.
From his possession, besides the tainted bribe money, an additional sum of 4,06,980 was seized. The present appellants had made an application before the Special Judge Vigilance Jaipur for release of the said amounts, claiming that the amount belongs to them. Because they had kept it with the data operator. The said application was not disposed of, but the trial was concluded wherein the respondent number 2 was acquitted. 406,980, there was no allegation that it is the bribe money. The same was confiscated to the state. Since we were not party, we had made an appeal under 450. The appeal is under section 454, my lord. The present appeal is under 454 for release of the property.
No, what is the finding supera that recovered cash of rupees 4,06,900?
No finding, your lordship. Only because since it is a prosecution has alleged that it is seized from the possession of the accused, the same is confiscated to the state along with the tainted tribe money.
No, it's all right, but how do you say that it is your money which has been kept?
We had made an application before the trial court for release of the money during trial also. The said applications were not disposed of.
It's all right, but one amount has been seized from X.
Yes, your lordship.
Taking a plea during trial that it is the money of Y and Z.
Yes, your lordship.
So how do you claim?
We are the said Y and Z, my lord. This is the plea of the respondent number 2 also.
You may
That
take
the money belongs to the present appellants.
that you may take the plea, but that is again to be appreciated in the context of the case. So the person who has alleged to have received the money from you, if he's totally silent about that.
No, that particular factum has already been reflected. That has already been come during trial of the entire proceeding, your lordship. The witnesses have admitted.
What admitted?
About the money, that the present money being kept with the data entry operator.
All right, we'll consider that first.
Yes, your lordship. Yes, your lordship.
Delay aspect be taken care of, then so Lekhantu, the London Mr. P. Gopinath Murthy, Land Council, appears through virtual mode from Civil Court Complex at Koraput, and submits that since the defect number 2 has been pointed out by the stamp reporter regarding limitation, as per the order dated 29/2/2024, he has filed IN number 543 of 2024 for condonation of delay. 4324 लिखे. Okay. Let the registry place the same on record. Let a copy of the IA 543 of 2024. How did you receive that copy? That
from the office of the Advocate General.
Advocate General, Asha.
So it has been filed. It has been filed in.
No, earlier filed, but this IA has been.
IA also filed through virtual VC Miller. VC.
I do not have any.
All right, I am asking the registry to supply a copy. Let a copy of the IA 543 of 2024 be filed by the appellant be supplied to Mr. Sanjay Kumar Das, Learning Standing Counsel for the Vigilance Department, and the matter be listed on 19th of March 2024 for consideration of the delay condonation.
Maintainability of the appeal.
First, let the delay be condoned, then we'll consider that.
Yes, my lord. My learned friend submitted that he has filed this application under section 454.
All right.
454 is not, no order has been passed by the learned trial court, my lord.
Right. For consideration of the, what is the delay has been pointed out by the stamp reporter?
Sir, the judgment was passed on 20th of February 2023.
102 days delay.
Judgment was passed on 20th February. I applied for certified copy on 1st of June.
So keep it on 19th March 2024. Yes. It will come on 19th March 2024.
Publish.
Yes, next.
Item 35.
35, Mr. Ghanshyam Muduli.
May I pray one line to be added?
Yes.
One line. The accused who has been added as respondent number 2, one DA case has been registered against him and charge sheet is going to be filed. Koraput Vigilance case number 27/14. This line may kindly be reflected in.
Mention it in the next. The London Council has left the VC also. Whatever you submit, mention it in his presence. He can answer it.
Okay,
Yes, what is the delay?
167 days, my lord.
100. What is this appeal for?
Order of acquittal.
Acquittal.
My lord.
What is the offense here?
323, 341, 294, 506, 325, 307, and 34 IPC.
No, he has been found guilty under some offenses. 323, 324 by 34, he was found guilty. He has been acquitted of 307, 506 by 34. This is the informant's appeal.
Yes.
Trilochian कौन था ना? Sharthi.
Shakti.
He is the informant in the case.
Yes, my lord.
This Hrishikesh Bajubandha and Nirakar Bajubandha are the accused persons.
Yes, my lord.
Okay, then how did you mention that it is an appeal under section 374(2) of the CRPC? It is not against conviction. You are challenging the order of acquittal of some of the offense. So the appropriate provision would be the proviso to section 372 CRPC. Are you having the CRPC with you? Come. Why the order? (372) CRPC. Come to the proviso and read it out.
No appeal shall lie from an judgment or order of criminal court except
Now you come to the proviso part.
provided that the victim
Please use the mic properly. Yes.
provided that the victim shall have a right to prefer
Right
an
to
appeal,
prefer. Yes.
prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offense or imposing inadequate compensation, and such appeal shall lie to court to which an appeal ordinarily lies against the order of a conviction of such court.
So you are the informant. The accused persons face trial. They have been acquitted for some offense. So if you have filed criminal appeal, it should be under proviso to section 372 CRPC, not 374(2). 374(2) is the case of conviction. If the accused want to challenge it in the higher court, that provision is there, right?
Yes.
So number 2 is that the order has been passed by the London Chief Judicial Magistrate, Assistant Session Judge. So ordinarily the appeal would lie to the Sessions Court, not to the High Court, against the acquittal order, because the word has been used in 374 proviso that the appeal shall lie, ordinarily lies against the order of conviction. So in case CJM or Assistant Session Judge would have convicted you, so the appeal would have been preferred ordinarily before the Sessions Court. In case the sentence would have been passed for more than 7 years, then you would have come to this court.
Yeah.
Okay. So ordinarily it lies to the Sessions Court. So this type of appeal would be maintainable before the Sessions Court, not here. So you withdraw this appeal, file it before the appropriate court, right?
Yes.
Lakhan, this CRLA has been filed under section 374(2) of the CRPC by the appellant Trilochian Sharthi, challenging the acquittal of the respondent number 2 and 3, namely Hrishikesh Bajubandha and Nirakar Bajubandha, respectively, of the charges under section 341, 307, 506 by 34 of the Indian Penal Code, passed by the Learned Chief Judicial Magistrate cum Assistant Session Judge Gajapati Paralakhemundi in ST case number 12 of 2019 by judgment and order dated 4th February 2023, while convicting the respondents number 2 and 3 under section 323, 324 by 34 of the Indian Penal Code. Proviso to section 372 of CRPC reads as follows. Quote the proviso. In view of this provision, since against the order of acquittal of the aforesaid offences 341, 307, 506 by 34 of the IPC by the Learned Trial Court, appeal is maintainable in the Court of Session. Learned Counsel for the appellant seeks permission of this court to withdraw this appeal and prefer the appeal before the appropriate court. In case the appeal is filed within a period of 2 weeks from today, an application is filed for condoning the delay in filing the appeal, the Learned Appellate Court shall take into account the provision under Section 14 of the Limitation Act for condoning the delay. You have filed the true copy or the certified copy? True copy. ଦେଖିଲେ ସେ କପିଟାକୁ କ'ଣ ଦେଇଛନ୍ତି ତା ଦେହରେ ଅରିଜିନାଲ ସିଲ୍ ଫିଲ୍ ଅଛି ଅଛି ହେଲା the copy of the impugned judgment which has been filed be returned to the Learned Counsel for the appellant on being substituted with the Xerox copy. Disposed of for them. Rest of the matter after lunch will take. And so also this IA is also disposed of.
Item 36.
2 weeks time to remove the defect.
All right. Learned Counsel for the appellant 2 weeks time to remove the defects as pointed out by the stamp reporter. Put up this matter after the defects are removed.
Item 37.
May I please judgeships? The appellant acquittal judgment order dated 26/6/2023 in acquitting for respondent number 224 for the appellant's punishment.
So you have to remove a defect as pointed out by the stamp reporter. Are you aware what are the defects pointed out?
Appeal is also not maintained. Appeal is not maintainable. The acquittal challenging the acquittal order matter of assistant session judges kindly reply. Page 9.
Yes, it is maintainable before the session judge Anandpur because against the order of the assistant session judge, ordinarily the appeal lies to the sessions court. So you are to withdraw this and approach before the London session judge Keunjhar. Okay, take down. This criminal appeal has been filed by S.K.SAHOO, the informant in Anandapur PS case number. He's the informant, na?
Yes, madam.
Anandapur PS case number 118 dated 27/9/2015, challenging the judgment and order dated 26/6/2023, passed by the London Assistant Session Judge Anandapur in acquitting the respondents number 2, 3, and 4, namely Gauranga Ghadai, Ganeshwar Ghadai, and Saraswati Ghadai, of the charges under section 341, 323, 325, 294, 354, 506, 307, Y34 of the Indian Penal Code. Provide to section 372 of CRPC reads as follows. Quote the paragraphs on. Since appeal against the order of London Assistant Session Judge Anandapur ordinarily lies to Session Judge Keunjhar, the London Counsel for the appellant seeks permission to withdraw this appeal in order to approach the appropriate court. In view of such submission made, the appeal is disposed of giving liberty to the petitioner to approach the Session Judge Keunjhar for appropriate relief, and if the appeal is filed within a period of 2 weeks from today with an application for condonation of delay, the London Appellate Court shall take into account the provision under Section 14 of the Limitation Act in condoning the delay. Our judgment file करछन्ति seal mara. The copy of the judgment be returned to the London Counsel for the appellant on being substituted with a Xerox copy. Yes. Dispose of.
Item 38.
Yes, Mr. K.K. Behra. What is the defect? Defect number 9. Name of the
Custody certificate has come up.
Huh?
Custody certificate has been called for.
Custody certificate.
That is available with you.
Yes, yes, oblige.
Item 38.
Please, your lordship. My lord, during last course of hearing, my lord has wanted me to file the trial court petition, my lord, which I have filed. I have filed that copy of that petition.
What is this petition for?
That for release of my passport. That petition I have filed.
Who has seized your passport?
My lord, as per the direction of the court, I submitted that in terms of a bail order. There was a condition. So
the trial court granted you bail?
Yes, ma'am.
Or the bail was granted by the High Court?
No. Trial court. My lord, I was not arrested. I was after submission of charge sheet, summons were issued. Pursuant to summon, I appeared before the court, and trial court granted me bail pursuant to the judgment of the apex court. And in that,
to the judgment of the apex court mean?
There was a judgment of the apex court in
Amanpreet Singh.
SLP number.
Lordship is talking about Amanpreet Singh's judgment. If somebody is not arrested before the filing of the charge sheet.
Basing on that,
I thought that the petitioner earlier opposed this.
No.
Okay.
And he was granted bail subject to 3 conditions. One is to 20,000.
Where is that condition?
That was there.
Next.
The 3 conditions. One is 20,000 to solvency.
order ka execute condition impose heichi.
Se order ta mu deini.
And apno deposit kale.
Ha. Seta भी नहीं order लिखी ना दिया गया. से ट्राई माने bail order लिखी ना दी खाली कही देले हमें we gave 5 lakhs.
Where is the proof that your passport has been deposited in the trial court?
That they have taken my lord.
अरे कौन आपण सब जी
सेटा order सेटा
आपण गोटे order देखु नांती आपण को दिन दाखल कले कि
16/10 रे
आपण जेतले passport ता deposit कले
that is reflected in the rejection order my lord.
Where is that?
Annexure 12. Last time your lordship had seen.
Just this order arises out of the so for release of the passport bearing number so for 2 months. Okay. This petitioner has submitted that being summoned, the petitioner appeared before this court on so he was released on bail on the same day. And in compliance with the condition imposed on him, he had submitted the passport before this court. However, accused petitioner has renewed earlier contract with to do some research work as per the. In view of such contract, he requests to travel at least 3 times in a year to requisition issued by the said university. He has also stated he had booked a ticket to so his son so Eta diyo. You come to the page number after the discussion has been made about the submission noted down
Page 130.
On perusal of the case record.
Yes.
Please place it.
Yes. On perusal of the case record, it reveals that on 16/10/2023.
Go slowly. Yes.
16/10/2023, the accused petitioner, namely Sam Vasudev Rao, had appeared and he had been released on bail by this court in view of the order dated 2/9/2021 passed by the Honorable Supreme Court of India in Criminal Appeal number 929 of 2021, arising out of SLP number such and such, Amarpreet Singh versus CBI to Director. As per the direction of the Honorable Supreme Court India, this court has imposed some conditions for release of accused petitioner on bail, out of which one was the surrender of his passport. In compliance to that order, the accused petitioner has deposited his passport before this court on 16/10/2023 and had been released on bail. The intention of this court, while imposing such condition as per the direction of the Honorable Apex Court of India, was to restrict him from fleeing from the reach of the court by using his passport. Since the allegation against the petitioner is that he has misappropriated huge amount of money receiving from gullible investors by entering into criminal conspiracy with other accused persons, he should not be allowed to move away from the reach of the court. Moreover, one of the conditions of the bail order of the accused is that he shall not default in personal attendance of the court as and when required. Under the circumstances, the passport of the accused petitioner cannot be released for the purpose of his visit to abroad for the period sought for and or for a other purpose. As such, I am not inclined to allow the petition.
Where is your passport copy?
But I have filed it. That is not this passport, because this was my earlier passport in Annexure 7, which I have filed for the showing to your lordship that earlier during pendency of the investigation and even after charge sheet, I have traveled and I have returned. That is Annexure 7. Your lordship, kindly see.
In the passport.
Yes.
What is the validity period?
That is
21, your lordship, the expiry is shown. 27, if your lordship will come to page 124.
124.
From the document, it is reflected that it has expired in 2021.
No. That is expired. Thereafter I renewed, and the renewed passport has been filed before the court.
କାହିଁ ଆପଣ କପି କଣ ପାଇଁ?
ସେଟା କୋର୍ଟରେ ଦେଇ ଦେଇଛି ନା originalଟା. I don't have the copy, my lord.
Why didn't you have copy when you are filing a?
No, original I have filed, my lord, before the court. I don't have a copy of.
Are you not supposed to keep a Xerox copy of the same? Because this passport indicates.
No. This passport copy I have shown that earlier I have traveled. That is the stamping I have shown. Not that this is the passport I have deposited before the court. I have deposited before the court the renewed passport, which is valid.
This date of expiry is 20.
No, that is expired.
So you have renewed it. So where is the documentary proof?
That is before the court, my lord, before the trial court.
So if your lordship can interject in page 123, lordships will see that there is a date of travel. So foreign tickets you can't book your lordships unless until you have a valid passport.
No.
Passport number they will ask. The passport number টা foreign color.
Visa ବେଳକୁ ଦରକାର ନା ଟିକଟ ବୁକ୍ କଲା ବେଳକୁ
No, I just want to know that you have a valid passport. You want to travel outside.
That valid passport I have already deposited before the court, my lord.
How can have you taken an averment?
And yes, I have mentioned the passport number. I have mentioned the passport
number is this 2234.
No. The renewed passport number I have mentioned in my prayer, my lord. Your lordship may kindly come to my prayer. Page number 14. This is the passport number I have deposited.
The passport number, it's all right, but unless it's a valid passport.
Yes, it is a valid passport, man.
You don't take that everything will be granted, whatever you say, without any aberment, without any document.
Because my lord, I have.
Where have you taken the aberment that after the expiry of the validity period, I have renewed it. It is now valid up to this period. Where is that aberment?
That aberment I have not.
Then.
Oh, your lordships. If your lordships will come to the prayer, please read the passport number, your lordships, in page 14.
Yeah.
This is the expiry part of the passport number. This is not the new number.
Exactly, I'm asking him.
Got it. If your lordships will come to page 14 and 124 and read it conjointly, the prayer here is the release of the passport J2344197. Lordship may kindly come to page 124. This is that expired passport. This is not a new passport.
If you get this particular passport in which it has already expired, so how it will enable you?
In that case, my lord, may I pray one thing? Your lordship, can your lordship ask the trial court to give a report?
No. Why? I will ask you. Why don't you apply? Because get the certified copy of that document.
Yes, that I can come. That
come with that suit, so that because you are not taking.
No. That I can.
I'm asking you that if the copy is applied for, it will be handed over to you. That passport copy, certified copy, it can be given to you, so that to prove that it is now as on date, it is a valid one.
This is a valid one, but
you are taking everything for granted.
No.
Then
valid passport without a valid passport, how can
that is exactly the reason why I'm asking you. That the document which has been filed, it shows that it is already expired. That period has already expired. But
no, this passport I have not filed. This passport I have deposited. That is
prayer, your lordship, is that
prayer is to release the old
Yes, my
passport.
lord, I will. If you,
All
I will get a
Take-
certified copy.
Take down. The prayer made in this revision petition is for interim release of passport number Z2344197 in favor of the petitioner Shyam Basudev Rao, and to permit him to travel Netherlands and Sweden for a period of 2 months. The passport which has been annexed to this revision petition, date दिखाई दो.
My lord, this passport I have not
Page 124.
cited as
Please,
a
please.
proof of yeah.
Where is that? Page number?
Page 124.
Okay.
Page number.
As page number 124 indicates that the validity period has expired since 28/8/2021. The London Council for the petitioner submitted that the passport has already been renewed, and as on date it is a valid one. However, the copy of the renewed passport has not been filed with the revision petition, nor any averment has been taken in the revision petition that after expiry or prior to the expiry of the validity period, renewal was application was made and it has been allowed, and up to what period it has been granted. The London Council for the petitioner, when this court asks the petitioner to file a copy of the passport which has been renewed, the London Council for the petitioner submitted that it is not now available with him and it has already been deposited in the before the trial court. In view of such submission, and he wants to produce a copy of the same. If a certified copy of the passport which is stated to have been which has been deposited by the petitioner is applied for, the London trial court shall give the copy thereof if proper application is made. Shall hand over. Kebe rakhibi kuhନ୍ତୁ?
28 ତାରିଖ
Put up this matter on 28th March
Your Lordship, from
2020.
28, Your Lordship, from 28 to 3rd, I have some difficulty. 4th April, any date after the.
Right, on 4th April 2024. Yes.
My lord, ଆଉ ଗୋଟେ ଜିନିଷ ଯଦି ତାପରେ ଜେରକ୍ସ କପି ଥିବ ମଧ୍ୟ can I produce ପଚାରି ଦେବି ଯଦି ରଖିଥିବେ if you can.
4th April. If a Xerox copy is filed, what is its admissibility?
ନାଇଁ ଏଇ ଯୋଉଟା ଡିପୋଜିଟ୍ କରିଛନ୍ତି ତାକୁ with affidavit କରିଛନ୍ତି.
Don't hypothetically.
Your Lordship, a copy of the bail order may also be.
Can Xerox copy
ରଖିଛନ୍ତି ନାଇଁ ମୁଁ ଜାଣିନି.
Just go. Don't.
And a certified copy of the order may be granted. Copy of this order.
Yes, next.
Your Lordship, a copy of the bail order may also be filed so that we can know what are the conditions.
Bail order.
Bail kona?
So bail order, the original bail order granting him bail. What conditions we don't know because it has not been filed.
ସେଥିରେ କିଛି condition ଲେଖି ନାହାନ୍ତି.
The bail order copy in pursuance to which the petitioner stated to have submitted the passport before the London trial court be filed before this court, so also be handed over to Mr. Sarthak Naik, London Special Public Prosecutor.
ସେଇଟାରେ order ରେ ମଧ୍ୟ କିଛି condition ଲେଖା ହେଇଛି.
Yes, next.
ମୁଁ ପଚାରିଲାରୁ ସେ କହିଲେ ଆଗ ଅନ୍ୟମାନଙ୍କ ଯୋଉ order ହେଇଥିଲା ସେଇ ଅନୁସାରେ ହେଇଛି.
Okay, next.
Item 49.
ଆପଣଙ୍କୁ ଗୋଟେ କୋର୍ଟ ପାସପୋର୍ଟ ଡିପୋଜିଟ୍ କରିବନି ବୋଲି ମାନେ କରିବ ବୋଲି କୌଣସି ଅର୍ଡର କରି ନାହିଁ.
କିଛି ସେ କହିଲେ
ଆପଣ କେମିତି ନେଇ ଦାଖଲ କରିଦେଲେ ପାସପୋର୍ଟ?
ଶୁଣନ୍ତୁ ମୁଁ ଥିଲି ନିଜେ.
ଆପଣ ଥିଲେ, ଏଇଟା କଣ ଘର କଥା?
ନାଇଁ ମୁଁ ନିଜେ ଥିଲି. କୋର୍ଟ ଓପନ କୋର୍ଟରେ କହିଲେ
ମୁଁ ଜାଣିନି କଣ ଆପଣଙ୍କର ମୌଖିକ କଣ ଘରେ
ଅର୍ଡର କିଛି ଲେଖେ ଅର୍ଡର ସାର୍ଟିଫାଇଡ କପି ଆସିଲା ପରେ ମୁଁ ପଚାରିଲି କୋର୍ଟକୁ. ମୁଁ କହିଲି ଆଜ୍ଞା ଆପଣ ଅର୍ଡର
how can you deposit if you insist file an pass an order to that effect? Or you challenge that order?
Show that order to your lordship.
It's all right. At that point of time, you could have come to this court Sir, this court is insisting on such a condition which is not there.
କଷ୍ଟଡିରେ ଲୋକକୁ ରଖି ସାରିକି ଆଜ୍ଞା କେମିତି କହିବି?
That is,
ଲୋକ କଷ୍ଟଡିରେ
I cannot advise you or what to do
ନାଇଁ,
or
ନାଇଁ,
not. Yes, next.
ଜାଣିଛି କିନ୍ତୁ
Next
କଣ
case.
କରିହବ ଆଜ୍ଞା?
Yes, next.
Lords, this
Item
is a
14.
release of passport, my lords.
Yes.
Straight away, take your lordship to page 144, which is a valid passport, 23/11/2032. 144.
Yes.
Your lordship can see it is valid till 23/11/2032.
Yeah.
So it's a valid passport.
Yeah.
Now, my lords, before I delve into the point, I made a short date chart, which will help your lordship to appreciate.
Now, what is your prayer in this?
My
occasion, please?
prayer is I am a green card holder. My wife is a citizen, American citizen. My daughter is an American citizen. My mother-in-law is an American citizen who is now was in hospital. Now she is in ventilator. I have filed all the documents, which is Annexure 3 series, which will evidence that she is on ventilator and she might pass away any day once the ventilator is taken out. My daughter, she is studying and her passport has also expired. As per US law, my lords, that the passport can only be renewed where in presence of both the parents in US. I have business concern in US. I have business concern in India as well. After Milord's charge sheet, I have traveled to US 49 times. That is evident, my lords, that I have filed. Your lordship may kindly see page.
No, your passport was seized by the.
No, it was one of the bail condition. Lordship may kindly turn to page number impugned order, page 13. Order is page 20 minutes.
Okay.
Let the accused, may I?
All right. Yes, that was a condition for.
Yes, release of passport.
Surrender the passport.
Surrender the passport. Now I will show your lordship a
Then
decision of the Supreme Court.
you just a minute.
I'm sorry.
You surrendered the passport on the
same
day.
Yes.
Okay. Then what happened?
Then on 6/12, I file a petition. That is page 21. The order arises of a petition dated so and so filed by defense counsel for the accused, namely Indrajit De White, which he had prayed to return passport for a period of 2 months with permission to leave India for US so and so. The prosecution has filed a written objection thereto, and hearing of the petition has already been completed. Peruse the case record. Learned counsel for the accused petitioner, namely Indrajit, they have submitted that being summoned after above, accused petitioner has appeared before the court on 9/10/2023. He was released on bail on the same day, and in compliance to the condition imposed on him while being released on bail, he had submitted his passport before the court. Full stop. However, the wife and minor daughter of the accused petitioner are now residing at USA, and being a green card holder, he is a regular visitor to USA. Even during investigation, in order to meet his family, he has visited US on various occasions. Learned defense counsel further submit that mother-in-law of the accused petitioner, namely Mrs. Mamani Goel, is an old lady of 72 years old, and she is suffering from acute respiratory failure with medical terms are there, my lords. She has been in and out of hospital and hospice facilities since November 2022. Was intubated on 25 November 2023. It should be 23. Has tracheotomy and some medical word. She was under regular medical care.
You come to the.
I come to the straight away. I come
on
to page
perusal of the
24.
case record. On perusal of the case.
On perusal of the case record, it reveals that on 9/11/2023, the accused petitioner, named Indrajit had appeared, and he has been released on bail by this court in view of the order passed in so and so Amanpreet Singh's case. As per the direction of the Honorable Supreme Court of India, this court has imposed some condition for release of the accused petitioner on bail, out of which one was to surrender his passport. In compliance to that order, The accused petitioner has deposited his passport before this court on 9/10/2023 and has been released on bail. The intention of the court, while imposing such condition as per the direction of the Honorable Apex Court, was to restrict him from fleeing from the reach of the court by using his passport. Since the allegation against the accused is that he has misappropriated huge amount of money received from the gullible investors by entering into criminal conspiracy with other co-accused, he should not be allowed to move away from the reach of this court. Moreover, one of the conditions of the bail order of the accused is that he shall not default in personal attendance of the court as and when required. Under such circumstances, the passport of the accused petitioner.
So what is the stage now?
Now stage is status quo. There is no evidence, nothing. No. Trial has not commenced.
Mr. Naik,
Yes, sir.
for how many months you have prayed for release of your
For
passport?
2 months I have prayed.
2 months.
Lordships, yesterday, before that,
There
your
are
Lordships.
3 reasons. May I just submit one? 3 reasons.
No,
One
you have given the reasons. I'm just
Your
asking.
Lordships,
the
yesterday,
reason is if I don't go within 1 year, my green card will be suspended.
All right.
your Lordships, yesterday,
Where is your petition that you have prayed for 2 months?
That's also reflected in the order.
Which is that order?
That order is on perusal the case record. It appears that he had been released on bail. This is
No, your petition copy which you
petition
filed
copy.
before the
Yes,
concerned court for release of the
I have that
passport.
petition. I have.
Because in the order, impugned order, it is not reflected for what, how many months you are seeking
Yes, it
for
is.
that.
It was 2 months, my lords. Here I just read it.
Court লেখা है जी।
Mukul, just give me a minute.
but your Lordships,
Yes.
your Lordships, yesterday night, I was served with a copy of the affidavit, one fresh affidavit. Lordships, I have not gone through it. This affidavit was filed last night.
That I don't press.
Just a minute. Yeah.
That is not. Your Lordship, yesterday night I received an application. If he's not pressing it, then it's already, Your Lordship. I can argue the remaining part.
I don't want to press it.
No, I just want to know that for 2 things.
Yes.
What is your prayer before the court below? For how many months you want release of
Page 21. Page 21.
Page 21. Let us see
This
that.
order arises of a petition dated 2/11/2023 filed by learned defense counsel for the accused, namely Injury Day, which he had prayed for return of his passport for a period of 2 months.
Okay, that is for 2 months.
Yes.
Now, at what stage this case is now? Because there is another condition that you should personally appear. That personally appearance.
As and when required.
No, as and when required. So that would arise when the trial commences.
Absolutely. I am grateful.
So,
I am grateful.
what is the stage now?
My knowledge is.
Mr. Naik?
Your Lordship, I'll find out the exact stage of the trial, Your Lordship.
No, whether I just want to know that whether the charge has been framed or anything like that. So unless that order is there, then you cannot. He's just asking for 2 months, and
Your Lordship, so when someone was issued to him, Your Lordship, first the someone was issued.
Someone usually issued when suppose they are not arrested.
No, Your Lordship, I'll tell the background of the case, Your Lordship. Someone was issued to him on 4/8/2023.
Yeah.
Then he sought for time on that day.
Okay.
After that, Your Lordship, on 14th August, Your Lordship can note it down. On 14th August, again someone was issued to him. He prayed for time.
Yeah.
Now, Your Lordship, during the pendency of the case, on 28th August, he sought for a time petition. On 30th, Your Lordship, on instructions I'm saying, on 30th August, Your Lordships, he was trying to fly abroad without informing either the trial court or the High Court. And Your Lordships, if Your Lordships will come to para 8 of my reply, Your Lordships, I filed a reply. I have taken that averment, Your Lordships. May I read it, Your Lordships? Para 8 of my reply.
That is the counter affidavit or what?
Yes, Your Lordship, I filed a short reply. It is a fact that he was deported from Kolkata airport by immigration authority with an undertaking for surrendering before the trial court. Then, Your Lordship, he appeared before the trial court on 9/10/2023. Therefore, he did not respect the summons. During the pendency of the summons, twice he asked for time or sought for time. The date, Your Lordship, I checked from the PP is 4/8/2023.
Hmm.
And another date, your lordships, is 14th August 2023. Your lordship may call for records also. 28 August, your lordships, he again filed a petition, time petition. During the pendency of the time petition, he tried to leave India. And the IO who has filed an affidavit has stated that it is a fact that he was deported from Kolkata airport by immigration authority, your lordships.
Okay.
With the undertaking of surrendering before the trial.
Now the fact remains that he has surrendered on 9/10/2023 and his passport is available with the court because that was the condition precedent for release and he has complied with such condition. Question is that he wants a temporary for a temporary period the passport is to be released, that is for 2 months. Now suppose you are not progressing with the trial and as on date there is no chance of the progress of the trial because of some reason, maybe some accused have not been arrested or something like that.
Your lordship, as a green card holder, the trial has not started. He himself is admitting the fact that he doesn't stay in India. If he's a green card holder, he's
no, he has not they are he has to come back to India. What is the question?
If it doesn't come back at this point of time, this is the undertaking which will give that I will come back.
If for that particular period, if visa is granted to him, let us say.
No, your lordship, he is saying that he's a green card holder. I think visa is not required. Sir can tell better.
Think of it, matter. Let us say that you are apprehending that suppose after 2 months he may not return.
Yes.
Okay, the passport is available with him, he may not return. So whether there is any way out to deal in such a situation. So passport is released, he will go. He has given a condition for 2 months it will be released. He is not returning from that place where he has gone. So whether there is option or there is any procedure available with you, or you are just say that we are undone, we cannot do anything in such a situation.
That procedure, your lordships, which is available under the law, I'll seek instructions and get back. But your lordship has already made an attempt in the pendency of the summons. Your lordship, look at his conduct. He is asking for time before the trial court. If your lordship
I followed it. I'm now let us say
the date is fixed on
you are posing a question, you are submitting that in case he goes out after taking this passport for 2 months and doesn't come back to India, then what will be done? Then whether there is any option available with you to take necessary steps in accordance with law against him in that way or not?
What steps can be taken, your lordship? Have to
you just consult that in such a thing. You just consult the passport authorities and take proper instruction from them that in such a
situation, also one. And your lordship wanted to know that whether he's a green card holder, the visa is for limited period of time, or he already has a visa forever in USA.
He wants to go for 2 months on the basis of this passport, which is a valid one he has shown. Your apprehension that this trial has not commenced, your apprehension whether it can be sorted out or that can be appropriate terms and condition will be fixed. But take instruction from the passport authority that in such a situation what can be done, what would be the appropriate terms and condition, that your apprehension would be over. So that instruction you can take, and that if a man goes for a limited period and doesn't come back, what are the steps available under law? So that instruction.
And you also find out the stage of the trial, how quickly the charge can be framed out.
Yes, obviously that you can take. I'm just asked you. He said that nothing has commenced in the trial court.
Because your lordship, the date was fixed on 11th November. January.
Right. You take instruction. Who is asking you not to take? All right, take.
I have a small submission.
Yes.
My green card is
take also instruction in that light, whether somebody his apprehension is because it's a cheat fund activities, na?
Your lordship may kindly then give me just 2 minutes.
One more thing, your lordship.
Just 2 minutes.
One more submission I miss out. Your lordship, the two co-accused in this case, the principal accused, their bail application was rejected by the Honorable Supreme Court. They are still in custody.
Yes.
When their bail application was rejected, your lordships, the court asked them to surrender. Both of them absconded, your lordships. NBW was issued against them, and after 1 month they surrender. And they are still in judicial custody, your lordships, after the submission of the final charge sheet also.
Okay, now this man, no,
There are
Mr.
two submissions.
This man has been released on bail, and you have not challenged the bail order.
One
is one of the condition is asking for a temporary. So you take instruction according.
because I have two submissions.
Yes, yes. Make your submission on the next date. Criminal revision number 690 of 2023. This revision petition has been filed challenging the order dated 6/2/2023 passed by the London Special Judge CBI Bhubaneswar in criminal miscase number bracket CMC number 630 of 2023, which arises out of SP number 5 of 2014, and for release of the original passport in favor of the petitioner. As it appears from the impugned order that the petitioner was directed to be released on bail by the London Trial Court as per order dated 6/12/2023 on his appearance, and with certain terms and conditions, and one of such condition is that he shall surrender his passport before the court. The petitioner stated to have complied with such order and surrendered his passport the London on the same day. The London counsel for the petitioner drew my attention to the copy of the passport, which is annexed to the revision petition as Annexure 3 series, which indicates that the validity period of the passport is till 23/11/2032. The Mr. Sarthak Naik, London counsel for the special public prosecutor appearing for the CBI, drew the attention of this court to the counter affidavit filed by on behalf of the opposite party, wherein it is mentioned in paragraph number 8 that the petitioner was deported from Calcutta airport by immigration authority with undertaking for surrendering before the London trial court, and thereafter the petitioner surrendered before the London trial court on 9/10/2023. The contention of the Land Council for the opposite party is that in case the petitioner, the passport is released in favor of the petitioner, even for a temporary period, there is every possibility of the petitioner not returning back to India to face the trial. And the accusation against the petitioner is that he has misappropriated a huge amount of money received from gullible investor by entering into criminal conspiracy with other co-accused persons. When a query was made to the London Council for both the parties about the stage of the proceeding in the trial court, the London Council Special Public Prosecutor seeks some time to obtain instruction in that respect. The London Council for the Special Public Prosecutor shall also obtain instruction to meet his apprehension that in case the petitioner is the passport is released in favor of the petitioner for a temporary period and he doesn't return back to India during that period, whether any procedure is available under law to trace him out and to produce him before the London trial court. Put up this matter, ask prayed for, put up this matter. When you want Mr. Naik?
Same date, your lordship, 4th April.
All right.
Plus, no, it will be
Put up
too
this
late.
matter on
28th, my lords.
4th April.
Yes, your lordships.
Both these matters arises out of
Yes, one case.
Trial.
Trial is one case. My lord, in previous matter, I have filed a trial court petition. Your lordship may take it on record. Item number 48.
Previous petition trial court petition has been filed, which is taken on record.
Yes,
Copy may be served to me. Lordship, a copy may be served to me. A copy may be served to me.
Acha, free copy of the order be Land Council for the the item number 48. Mr. Acharya Land Council submit that he has filed the petition which was filed before the Land trial court for release of the passport before the registry. Let the same be placed on record. Yes.
Lords, can I make a submission?
Yes. Next case.
Lords, my
Item
mother-in-law is on
15.
ventilator. Lords, can it be on 28th?
Sorry, he is having some difficulty. Item number 15.
The batch of matters where, my lord, discharge application dismissed. It's against that order, my lord. With 3 matters, I think, no? 3 in touch. Later.
So you are which for the state of Orissa?
My lord, today I have appeared for the informant in both the appeal.
All right, I'll hear you. So what order you are challenging here? Discharge application
Yes.
petition was rejected.
Yes.
That is the order dated 19/12/2023.
Yes.
And then it was fixed for consideration of charge on 17/1/2024. What happened on that day?
I'm pretty sure, my lord.
Mr. Patro?
My lord.
Whether the charge was framed on 17/1? Because once the charge is framed,
I'll have to
some
challenge.
amendment would be necessary.
Amendment.
Because about 2 months is going to be elapsed. So let us take it next week and you obtain instruction what has happened on 17 or any date you.
No, whatever date, my lord, I can always do it virtual, my lord.
All right.
My lord, my only request is, my lord, because this proceeding shouldn't proceed.
Who knows that it might have the charge might have been framed and witness might have been examined.
Witness has not been examined, I'm sure of that, my lord.
So if suppose charge has been framed, Mr. Das, are you not supposed to amend the petition and
Yes.
challenge that?
Yes.
So that is exactly I am asking you. So
Report may be called.
ଆପଣ ମାନେ ବୁଝିଦେବେ ପୁଣି ଗୋଟେ ରିପୋର୍ଟ କଣ? All right, take down. Are Mr. Yeshwan Das, Land Senior Advocate, and Mr. J.P. Patra, Land Counsel for the State of Orissa, Special Counsel. You are filed your Bina.
Bina and Baba
Land
Kumar
Counsel for the informant is present. The impugned order is dated 19/12/2023, passed by the Land Presiding Officer Designated Court of PID at Cuttack in city case number 13 of 2022, in which the petition filed by the petitioner for discharge has been rejected and the case has been posted to 17/1/2024 for consideration of the charge. When a query is made to the Land Council for both the parties as to whether on the date fixed charge has been framed or not, the Land Council for the Land Council want to obtain instruction in that respect. Let a report be called for from the Land Trial Court regarding the development made on 17/1/2024 onwards, and status report of the case. Status report be furnished to this court, and the registered judicial shall issue email to the concerned court for obtaining the report, which should reach on or before 20th of March
My learned
2024.
friend is here, my lord.
Charge has not been framed.
But are you not producing that order?
Yes, I'll produce.
Just that
Yes,
matter would have been over.
Yes, I'll produce.
Because,
On the next day, I'll produce.
So I will not call for the report.
And that may be called for in the meantime. Call for.
All right, status report.
And one of the co-accused has filed a discharge petition, and today date was fixed for hearing.
I have not the copy of the order. How can
Yes, I'll provide.
so the report would be available here, Mr. Das, by 20th. So tell me the date when you want to argue.
Whichever date, my lord, I fix.
Anytime April.
No, let him.
20th, 21st, whichever date.
20th, that report would come here. That is the order.
27th, my lord.
27th.
Yes.
All right. Put up list this matter on 27th March 2024. All right. If Mr. Pradhan, you can bring
Yes,
the
yes, I'll
in addition to
My
that.
lord, I am really an usurper as far as this first case, my lord, he is the counsel. So,
Pardon,
my lord, I just wanted to indicate one thing more, my lord. My lord, I was raising before my lord another matter regarding that Gajanan property where my lord had discharged in the teacher. My lord said that it had gone to Supreme Court. It had gone to Supreme Court and the SLP was dismissed.
Okay, okay.
I have got that also, my lord.
Okay. No, initially perhaps stay order was granted on.
No, my lord. At the initial stage, copy of the order.
Will not apply.
This is a copy of the order.
Okay, you keep it.
I'm
just keeping it.
Yes. But there's an interesting point, my lord, in this case. What's happening, my lord? These are all mutual concerns, my lord. My lord, fundamentally cooperative societies, my lord, they are the owners and they are the cooperative society. So therefore, they are mutual concerns, my lord. Under 25, if you to the company 25 for the Companies Act, and otherwise, my lord, mutual concern as a concept under the Income Tax Act. That means you cannot make a profit out of yourself or a loss out of yourself, and therefore you income tax is exempted. It's like those Cuttack Club and Bhubaneswar Club, my lord. So member, my lord, is really a owner, part owner, my lord. So in that case, my lord, where is the question of a deposit at all, my lord? So because if at all, it will be 406. Best case would be 406, supposing someone has defalcated or taking money, and Schedule 2 of the Cooperative Societies Act specifies what are the things to be done, my lord. Here, my lord, they are applied for a cooperative society, which was a employees cooperative society. That means only employees can become. And those employees are the person who are in management for the purpose of for doing this. One is director, one becomes president. There's a internal.
No, one thing is that. The second thing is that suppose there would have been some kind of thing which are to be done after receipt of that money by
No, there's nothing there. What happens? What happens?
Because in such type of cases, deposit accepted and they are given that we will do like this.
Then it won't be, my lord. Because you are yourself the owner and you are making the money to make a profit. And
no, that act came because the other persons, if deposit and with
outsiders,
some promise, right, sir.
If an outsider, my lord, supposing it was a cooperative bank, my lord, bit different. Or if it's a cooperative society, which that means it is a business cooperative society, my lord. Let's say, my lord, let's take the example of Amul. It's also a cooperative society, but it has business relationships. So therefore, it might go where they take, supposing outsiders, they take a deposit scheme they make. And they take a clearance from the government. That would be something different. My lord, here, my lord, is an employee cooperative, only an employee can become a member. So how can you make a profit or loss or whatever, my lord? That means essentially you are trying to punish yourself. So therefore, the scheme of the cooperative society is absolute, my lord. And it has its own check and balances. There's a 62 there, my lord, where disputes are put. There is also, my lord, definition of what is defalcation, what is this, that in Schedule 2. It is detailed out, my lord. So therefore, by any stretch of imagination, 6 won't apply, nor will the Act apply.
Okay, Mr. Patra, you have heard the submission and taken, ground must have been taken in that light. So ask the, to examine this law point, etc. Okay. Only. Apart from other things, because if it would not come within the definition of deposit as per that act, OPID Act, then the provision of OPID Act will, they are not, if other provisions are applicable, matter is different.
Yes,
but the main offense is, I think, Section 6 of the OPID Act. To attract that, one of the definition you have to satisfy is the deposit. Deposit as per that definition. So question is that in the factual scenario, in the background of this case, whatever the deposits have been made by the members of that society, whether that will be that will come within that definition or not. So if that is not satisfied, then
yes, that is the only point. Basically.
Okay.
Copy kindly provide.
What?
Copy.
Oh, you have not.
I am for the
you have so moto entered.
Today,
Okay.
yes.
All right. Write a copy of the criminal appeal memo along with the orders, along with the annexures be supplied. What is your good name, Learned Counsel?
I am Deepak Kumar Panda, but my
So where
senior
is
is
your
Prabhat
name?
Kumar Maan.
Your name is not appearing in the cause list.
Today I filed the Bhakala
Where have you filed?
in the counter.
Acha. Then कहाँ ना रे कौन तो?
Prabhat Kumar Mahanti.
V नामा अच्छी प्रभात कुमार मांती का ना रे? All right, Mr. Prabhat Kumar Mahanti, Land Council submit that he has entered appearance for whom?
Informant Bonita Mahapatra.
How many informants are there?
4 informants.
So you have entered appearance for one of them.
Bonita, yeah, no, there are several informants, Milord.
Achha, the
I am
informant.
appearing for Bonita Mahapatra, Nivedita Puhan,
Achha,
Omkar
he has
Mondal.
entered appearance for some of the
Informants.
for them. Hello? Some of the informants. Let a copy of the registry shall place the Wakalat Nama on record and the name of the Learned Council be reflected in the cause list and on the top of the brief. Hello? Let a copy of the appeal memo along with all the annexures be supplied to the Learned Council for the informant. Okay? And matter be listed. Dates दे देगा अपन पहले जो date था.
My lord can subject to pleasure of my lord. It can be 2 o'clock or something specific.
No problem. So it cancel. तो कितना दिन है ना 27 तारीख 27/3/2024 at 2 p.m. And you are ready for Friday.
Yes, yes. Oh, my lord, for that. I think